So this is a brief 20 minutes intense fireside chat by some of the leading experts on AI governance. And so we have Florence Xell here, who's going to be moderating the session. She will also be a commentator, but she's one of the experts on EU AI governance. And she's a professor at University of Lorraine, where she heads the Digital Governance and Sovereignty project. She holds the chair of Digital and Governance at Sciences Po. And she's currently a visiting professor here with the Cyber Policy Center. All right, so please join me in welcoming Florence and Danny and Gerald, and over to you.
Hello, thank you so much, Roland, for this very kind introduction. So I'm very honored and very pleased to be given this opportunity to moderate this panel today. So as you can probably hear, I'm from France. But I hope my accent will not be a bother for you. I have the pleasure to moderate a panel where Europe, America, and Asia are represented. And so with no further ado, I will introduce my co-panelists. And first, Danny Tobby, who is a medical doctor, a software founder, and a lawyer at DLA Paper. He chairs the DLA Paper's AI and data analytics practice. And Gerald So, who is an assistant professor of law at the Singapore Management University School of Law, who is the deputy director of the Center for Computational Law, and who works on AI regulation and liability, among other things. So I will try to introduce this panel with a few words about what's currently going on in the EU. Of course, since this morning, much has been said already about the AI Act, which was adopted 1 month ago. For many scholars who have been following the AI Act over the past years, it's been a very long journey. It has been for me because, as many of you did, I followed the various versions of these regulations that has changed so much times over the past few years. You might remember that the first version, the first proposition, the first proposal that was released by the EU Commission in 2021 was entirely focused on applications, on use cases, and was clearly a risk-based approach that really worked by identifying sensitive sectors, sensitive use cases with the most stringent obligations targeted at high-risk applications. And this is this logic of risk-based approach that is still present in the final version of the text, that is presented with this pyramid that everyone has probably seen, with on the top the prohibited applications and the high-risk applications, then the limited risk applications that require transparency, and then the no-risk or minimal risk applications. So it's one aspect and one original aspect of the AI Act, but of course, over time, things changed. ChatGPT was released. There was this very intense debate about foundation models, frontier models, general purpose AI models. So today we have in the very final version of the AI Act specific rules that apply not to use cases, but to the technology itself, to AI models themselves that are identified as general purpose AI models. It's not that easy to provide for rules that target a technology, and this creates definition issues, and we could of course discuss this. But we now have another layer, another significant part of the AI Act that really targets general purpose AI models, general purpose AI applications, general purpose AI systems with very strict rules. And of course, what we are going to discover in the next few months and years is how it is possible to enforce these rules, how it is possible to really mitigate risks thanks to this stringent and complicated framework. One last point about the AI Act, and I will, of course, let my co-panelists say a few words themselves. I want to highlight the fact that there is also another important directive that was adopted at the very same time in Europe, which is the new Product Liability Directive that includes specific provisions for software liability. And this is very new because until now, software was not really considered as a product in EU law. So now it's clear there is a strict liability attached to AI softwares in the EU. And of course, this is going to raise many issues. So I will stop here and probably let Danny say a few more words from the US perspective.
Thank you. Well, I have the easy job today because speaking about AI regulation in the US in 4 minutes is a lot easier than speaking about European regulation in 4 minutes. I probably only need 40 seconds. Look to Europe. So this is the Brussels effect that was instituted with GDPR, and we will see it again now with the AI Act from Europe. The US is, I don't know if you have heard, there's an election coming up. Nobody expects comprehensive AI legislation at the federal level in the United States. Recently, we had reintroduced a federal privacy bill, which is something that has been teased over a decade in the United States, including a very similar draft last year. And it's still a question mark whether that will be enacted in the United States. There's too many philosophical differences within the United States on governance of AI and data, I think, to see any major progress. But the AI Act matters to us in a few ways. One is, like GDPR, it has extraterritorial reach. So if you are a multinational company or a US-based company that is somehow affecting European citizens, the data of European citizens, putting AI into the European market, then you are, under the text of the rule, under the jurisdiction. Fines go up to potentially 7% of annual revenue. I'll say that again, 7% of annual revenue for companies that violate the most stringent standards, the prohibited acts. But even for the sort of higher risk violations, the penalties are still a percentage that is not zero of annual revenue. So it has people's attention. The second reason it matters in the United States is, as goes Brussels, so goes California. Kind of the day that the final text came out, we said, oh boy, here we go in California. And sure enough, just a couple days ago, there were headlines saying, yes, we have dozens and dozens of proposed bills in California already on what AI legislation should look like, but now we really like what Europe's done, so let's do something like that. So look for that being the sort of, just as CCPA followed GDPR, we'll probably have a California state-based version. There's activity on the federal side in the executive branch. The White House has put out 2 executive orders. One basically marshaling the federal administrative state to use the tools it already has to regulate and enforce against AI. We've already seen fines, even before the executive order, up to almost $1 billion for, let's say, illegal uses of algorithms, and several billions of dollars when it comes to things you're familiar with, like Cambridge Analytica. So there is a fair amount of activity, notwithstanding a lack of new legislation. And then finally, I would say at the state level, just look for a patchwork. Every state wants to pass an AI law, but it's a potpourri. Some people have, pulled the ball from the bingo machine and said, okay, we're going to regulate biometric screening of Zoom video interviews. Okay. Louisiana has come out and said, no, our bill, we're going to have a registry of large language models. Okay, well, the world is safe now. There are rules down to the municipal level, including New York has a rule now that if you're going to use AI in hiring, there are requirements for testing and notice and disclosure and ability to opt out. There's several states like that. So it's just a wide range of legislation that chips at different parts of the problem, but not comprehensive. And just like with privacy, I think we're going to be living with that challenge for some time.
Thank you so much. Gerald?
Right, so I've been asked to represent Asia, which is a region home to 4.5 billion people. And not all of us, in fact, no one actually thinks of themselves as Asian in my part of the world. So yeah, easy job. I'll try to give a general flavor of what people are concerned about over there, and I'll talk a little bit about what Singapore is doing, because that's what I know the most. So the keyword in Asia, or I overgeneralize, but one of the biggest concerns, because Asia is really the most diverse region in the world in terms of languages, cultures, and legal systems, it's fragmentation. It seems increasingly likely that everyone is going to come up with a different set of rules for AI, and that companies are just going to have to deal with it. The translation costs involved as a cost of doing business there, right? So the reason for this is really quite simple. AI has become valuable enough to be political, and increasingly we see that legal decisions are shaped by non-legal considerations. There are some countries, these considerations are dominated by geopolitics. Some countries care more about social policy and control, and other countries care more about industrial and economic policy. So in Singapore, where I'm from, the government has been generally taking a more pragmatic approach to this, because we realize that as a small nation of 5 million people, that I should clarify is about 2,300 miles south of China, we're never going to be, always going to be a standard taker in terms of the technology as well as the regulation, right? So the play has always been to try to position ourselves as a hub for doing business, as a platform where businesses can set up and train their models and so on. So what the government has been doing along these lines are two things and a few more things. The first I would highlight is this thing called the AI Model Governance Framework, which was first published in 2019 and was updated in 2021, and there was a patch for generative AI in 2023. So you can guess from the term governance framework that it is a voluntary framework that has generally broad principles like, your model should be fair and transparent and explainable. So it's not hard regulation. It's not something that is completely binding. But where it differs from the general broad statements that many people have put out is that it comes with a set of use cases and case studies that identify certain companies that have worked very closely with the regulators to put in place certain procedures and workflows that live up to those principles. And so it becomes a reference guide for other companies for practical compliance. That's the governance framework. The second thing I would highlight is what we call the AI Verify. So if you go on GitHub and you search for AI Verify, you will see that it is an open source library that's created and maintained by the government. I know that gives some connotations to it. But if you download it and you run it, you'll see that it's meant to help businesses run a battery of standard AI fairness and bias metrics like counterfactuals and so on. And it produces a report that is in the format that the regulators expect. So the idea is that with that library, you can reduce the legal friction involved in making sure you comply. Now, the one catch with this is that this is all pre-Gen AI, so it's quite hard to have these simple fairness metrics, right, for Gen AI, and that's something that the people I know in the ministries are working on right now, right? Let me see what else. Yeah, I think I will kind of stop at that, but I will just point out that the overall play has generally just been to try to put up something practical and to reduce fragmentation. So one thing I must highlight is that I think last year the Singapore government spoke with the US NIST, Institute of Standards and something, to try to convince people to get on board this AI Verify thing. So the idea is that if you use AI Verify and you have the report, it's not only good for Singapore, but it's good for the US and probably, hopefully, other countries. So we would try to reduce that fragmentation. That's all.
Thank you very much. We have time left to take questions from the audience, so feel free to. I think you have 2 mics.
Yes, thank you, Florence. I just have a quick question regarding the regulatory sandbox. Under the EU AI Act, can we draw analogies from the GDPR sandbox? Do you see similarity, or can we predict where the EU AI Act would go?
Yes, so I see similarities. Sandboxes have been an argument for some time now to say, well, we are not stifling innovation, we are trying to promote our companies. And you might have seen that you have in the AI Act a sandbox mechanism that is provided by the regulation, but also a real-time, I think it's a real-time experience that is provided by the regulation as well. And it's another mechanism that is added to the sandbox mechanism that is provided by the regulation. So yes, however, and as a French scholar, I can speak about my country. In practice, it's not that easy to implement those mechanisms, and I think that at some point we should have we should be able to take stock of the situation. Is it working? Is it working when we look at the GDPR? Will it work in this case? I could say that, for example, in France, we are facing huge enforcement issues with all those EU regulations. It's true with the GDPR, it's true with the DSA, which is currently the challenge. And so we'll see how it works. It's not that easy for regulators to implement those sandbox mechanisms. So I'm a little bit reserved about these provisions, but we'll see how it works in practice.
Right.
And in the case of the AI Act, we have the AI Office that has been created at the EU level, which is very unusual. So it's a new department within the EU Commission that will be in charge of following all this, which will probably help to have a better implementation of the regulation.
Right. And from the industry's perspective, how would you advise the companies to be prepared for the regulatory?
So this is a tough question. I've already been asked, because I'm very cautious when I answer these kind of questions. Of course, and it has been said since this morning, and since this morning multiple times, this regulation has a worldwide impact. It's really an extraterritorial regulation. And of course, what I would say to an AI company here in the US is, of course, if this company wants its AI product to be accessible within the EU, make sure that you comply with those main provisions, because there will be fines and they can be high. So my very cautious and very broad advice to companies, to AI companies, would be, of course, to closely follow how this regulation is implemented.
Yeah, I'll jump in on that and give a private practice view, because we're now in the process of helping companies both create roadmaps to get in compliance with the AIA over the next, let's say 1 year to 2 years. And then also helping companies where either we or someone else already set up an internal AI governance to make sure that it's now harmonized with the European law. And I'll say a few things. I mean, one is, the law is 900 pages and light on details. So that gives you a little bit of space to design to commercial reasonability. So for example, there are 4 buckets of risk categories, but it's very vague and not adjudicated at this point what falls in which categories. So we focus on the prohibited categories. Those are fairly easy to distinguish. The minimal risk categories, that's almost a meaningless category. The example they give is spam filters. Okay, well, I don't think anybody was about to put the spam filter through their AI governance funnel. So you're really focusing on that high risk versus low risk distinction. And there, honestly, it's so fuzzy. Because you have sort of the catch-alls, then you have the Annex 3 with specific examples, which are still fairly open-ended. It just becomes a business decision. And I think the answer is, if you use a good degree of common sense and say, is this an AI that could hurt somebody, or that's going to decide somebody's rights? You know, are they going to get a job? Are they going to get health care? You know, those are the types of things. Is it a safety component of an infrastructure system or something like that? Those are the areas where we really focus. And it's okay to err one way or another right at the margin, but the things that really have safety impact, we're saying just go ahead and, you know, you're doing impact assessments, you're red teaming, you're doing a FRIA. No one knows exactly what that's going to look like yet, but you're going to do it. And so we're getting people set up in that way, and then the AI Safety Committee and others are going to be putting out more paper in the next 6 months about what do these impact assessments actually look like, what's required.
Okay, it was a very short fireside chat, and I think we have to stop now, but happy to continue the discussion during the break, hopefully. So thank you so much for your participation.